I'm Andy Manatos, a member of the board of the Committee for Citizen Awareness. Welcome to the videotape, Your Court System and You. We hope to make interesting to you this important information about your courts. No, your court. No, our court system, which handles peacefully our disputes. Yes, that's it. This videotape will bring the subject of the court system to life for you. It will also share with you special aspects of the courts in your state and locale. I would like to now introduce to you the host who is bringing this videotape to your area.
Hi, my name is Denise Floyd. I am President and CEO of Fort Sill Federal Credit Union. We believe that since the September 11, 2001 attack on America, our country and our democracy became even more important to the life of every one of us. It became clear on that day that our democracy and each of us is threatened regardless of our ethnic or economic background, personal philosophy, or geographical location. We are in this together. However, what happened on September 11th can become a defining moment for our country. It can leave a positive legacy for us, our children, and grandchildren. It can strengthen what our attackers oppose, our American system that brings sustained freedom to us and to the vast number of countries around the world that have modeled their government after ours. You can do your duty as an American by helping others better understand what it truly means to be an American. This videotape is about the American court system. 80% of us say we don't really understand how our court system works. To tell us where the courts fit in our government, I would like to introduce the person selected by the people in this area to help them deal with our government in Washington, D.C., our local member of Congress.
Hello, I'm J.C. Watts Jr., your representative in the U.S. House of Representatives. I serve you in Washington, D.C. with your U.S. Senators Nichols and Inhofe. How does the court system fit into your government in Washington, D.C.? Well, most people usually know a fair amount about the two branches of government that make our nation's laws and policies. They tend to know a fair amount about the legislative branch based in the U.S. Capitol building where I represent you, and many understand about the branch that administers our nation's laws and operates our country's national government, the executive branch, directed by the President from the White House. This video focuses on the third branch, the judicial branch, which decides whether the people have broken the law, settles disputes among our citizens, and disagreements about what the laws mean. It will help those of us who live in the 4th Congressional District of Oklahoma know such basic but important things as which courthouse to go to if we need to use our courts.
In a democracy, you own your government, including your courts. For example, who owns the Lincoln Memorial more than you do? If you persuaded a majority of your co-owners or fellow Americans to agree with you and passed a law, you could paint it pink, as long as it didn't violate the list of principles for which our country stands, our Constitution. The usually dry subject of the courts has interesting aspects, as do all sorts of subjects. Did you know, for example, that humans are the only animals which cry? Or that President James Madison weighed only 100 pounds, while President William Howard Taft weighed 350. We hope you find what we have to tell you about the courts similarly interesting. Does your court system really affect your life? The answer is yes, in many ways. In the following example of an all too frequent happening around the world, put yourself in this family. It's 2 in the morning. Loud pounding on your door awakens everyone. The police sees a member of your family who has committed no crime. You can't find out why or where your family member was taken. Could such a knock in the night happen to you? 3 out of 4 law-abiding people in countries around the world have no reliable guarantees against or ways to counter such unjustified knocks in the night. Why does this still happen in other countries to people who have not broken the law, but not in America? The answer is that many American men and women have worked hard to make sure that your democracy and your Constitution don't allow it. It's the third branch of your democracy, the court system, which particularly helps protect the rights and freedoms of all, the criminals and the law-abiding. Your courts are not controlled by the parts of your government that make the laws or the parts that have the police power to enforce them. So your courts are free to protect you against possible government abuses. Your courts are controlled by the Constitution, and only you have the power to change that. What is your American court system, and how does it work for you? The system looks very complex, but it's really quite simple. You have only two major groups of courts in America. The first group of courts involves what some refer to as the feds, or the federal government in Washington, D.C. These courts handle disputes about laws made in Washington, D.C.'s Capitol building and signed in the White House by your president. These courts, which are located in many states, also handle disputes about the U.S. Constitution, as well as major disputes which reach beyond any single state. The Fed's laws, for example, the one that requires cigarettes to be labeled as hazardous to your health, apply the same way in every state in your nation or federation. What do you think they call this first group of courts, which handle federal laws throughout your federation? They are logically called the federal courts. The only other major group of courts are those which each state and the District of Columbia has to handle disputes involving laws made within those boundaries. These laws are made by each state's governments, city and town governments, county government, and state government. Unlike federal laws, state laws differ from state to state. In South Carolina, for example, the state allows people to sell firecrackers which explode. Sell them in North Carolina, and you can be fined or even go to jail. This second group of courts, which handles that state's laws only in that state, is logically called the state courts. That's all there is to it. There's one group of courts for the laws made within each state applying to that state, and there's another group of courts for handling the laws made by your federal government in Washington, D.C., which apply to the whole country. That should be easy for all of us to understand, except maybe for the guy who stayed up all night studying for his blood test. Both groups of courts, federal and state, have three different levels. To help you remember forever that there are three levels of both courts, we will liken them in this videotape to the three colors of the traffic signal: green, yellow, and red. You always start driving when you see the green light, and likewise you start in both the federal system and the state courts at what we are calling the green light level. The green light level is what you normally see on television when witnesses are questioned by lawyers. Most people don't know that trials, as most people picture them, occur only at the starting level, the green light level. The federal courts always call their first level, or green light level, the federal district court. In the state courts, there are different names for the green light or trial level. We will cover yours later. After a trial is held, if you or your opponent in court are unhappy about how your trial was handled at the trial court level, or green light level, you can appeal for help. You would go in nearly all states to the second level, or what we are calling the yellow light level of courts. Let's now look at the second level, or yellow light level. Since this level handles only appeals for help, they are logically called, in both the federal and state systems, the courts of appeals, or appellate courts. Remember, these courts do not hold trials where witnesses are being questioned in a courtroom. Instead, they make decisions based on written information and lawyers' presentations about what happened at the green light level. Following the decision by the Court of Appeals, if you or your opponent want to appeal for more help, you would try to go to the third level, the top level, the supreme level. Using our traffic light analogy, it would be the red light level. Calling it the red light level fits because this would be your last level of appeal where you must stop. This supreme level of appeals usually considers only those cases which could be very important in the future of many people. At the federal Supreme Court level, there are 9 justices. At this federal red light level, only about 100 out of the 6,000 appeals are heard each year, fewer than 2%. At the state court's supreme level, about 70% of those who appeal get heard. This supreme, or red light level of appeals, is logically called the Supreme Court in the federal courts and is called the state Supreme Court in most states. Congratulations. Take a breather. You are now among the top 20% of all Americans of any age in your understanding of your court system. To stay in that group, all you need to remember is that there are two major groups of courts, the federal courts and the state courts. And both groups, with few exceptions, allow you the possibility of using three levels, like a traffic light's three colors, green, yellow, and red. One at the trial level, one at the appeal level, and one at the supreme appeal level. Amazingly simple, isn't it? And it looks so complicated. In the future, you will hear unfamiliar court names, but don't worry. All you need to know is that all of them fit into one of the three levels of one of the two court systems. Now you will hear about your courts from one of your Supreme Court justices, Ruth Bader Ginsburg.
Hello, I am Ruth Bader Ginsburg, a Justice of the Supreme Court of the United States. In our democracy, the people elect members of Congress and a president to make and enforce our laws. We believe the majority should govern, but we also believe the rights of minorities and of individuals must be respected. The judiciary is the branch of government that resolves disputes and safeguards the people's rights. Members of the Supreme Court and of all federal courts are appointed for life so they can decide cases and protect rights fairly and fearlessly without worrying about the next election. The courts protect the rights of people to speak and worship freely and to be safe from unfair prosecutions and improper searches of their homes and offices. Decisions by the Supreme Court assure that people will not be kept apart in schools or other public places on the basis of their race or in any way treated with less than equal dignity because of their race, religion, national origin, or sex. And in a case brought on behalf of young people, the Supreme Court ruled that a high school principal could not prohibit students from wearing black armbands to protest a war. Our job is to help make sure that liberty and justice for all are not just words, but everyday realities for all people in the United States.
Thank you, Justice Ginsburg. The vast majority of us will only go to one level of one court system, the green light level or trial level of our state court. To handle the large number of disputes, including disputed traffic tickets, your green light level of state court is divided into two categories: courts for minor and major disputes. Now that you understand the basic structure of your court systems, let me tell you some unique aspects of the courts in your particular state. Your state's trial level is called district court for more serious cases and municipal court or municipal criminal court for less serious cases. In your state, the decisions of who wins and who loses at this trial level are made by a judge or a jury. Your state requires a unanimous vote by a jury to convict an accused person in a criminal case and a majority vote in a civil case. Civil cases can be appealed in your state to a second level of courts, called the Court of Appeals. It decides each case with 3 judges. The third level of courts in your state, which handles final civil appeals, is called the Supreme Court. The third level of courts, which handles the only appeal of criminal cases, is called the Court of Criminal Appeals. Now that you know how your courts are set up, let's walk through a couple of imaginary legal disputes and see how the process works and what the legal terminology means. Court cases are either criminal or civil. Criminal cases are for crimes, laws broken, people found guilty, go to jail and pay fines. Civil cases, on the other hand, deal with disputes between individuals and organizations. lawsuits over property or money or injury or divorce, and many other differences of opinion. Let's first look at a civil case. See if you can guess the outcome. A young woman buys an expensive dress for her senior prom. She plans to pay for it and pay for college with money she will earn from a modeling job she just landed. She uses a moisturizing lotion, we'll call it Hot Skin, and she gets a rash all over which her doctor says will not go away for weeks. She doesn't go to the prom, she loses her modeling job, and even her boyfriend. By the way, the name of the young woman is Barry Upset. Barry writes to Hot Skin asking them to pay for her prom dress and everything they have caused her to miss, money from her modeling job, the pleasure of the prom, and graduation. But instead of sending money to cover all this, the company sends Miss Upset another bottle of Hot Skin. So Barry Upset looks in the phone book for the number of a lawyer that a friend of hers has heard about. The lawyer she hires also writes to the company trying to get them to pay without going to court, but is unsuccessful. Barry now has two options: forget it or rely on the law and the courts and file a lawsuit. She decides to sue in state court. Hot Skin's president hasn't broken any criminal laws and won't go to jail if his company loses. So Barry's case goes to non-criminal or civil court to try to get Barry the money for the damage she has suffered. There are various courts in the trial level of her state civil court in which her problem would not fit. The family division covers divorce. The probate division covers wills. The landlord-tenant division covers evictions. And the juvenile division covers young people. Barry's lawyer will begin in court by filing a short written paper explaining her problem. The paper is called a complaint. Barry kiddingly says her complaint should qualify her to be called in court the complaintiff. She's close. She's actually called the plaintiff. Hot Skin, which must defend itself against Barry, will be called in court the defendant. Hot Skin's lawyer will answer Barry's complaint with a short written paper called the answer. After filing the complaint and answer, 9 out of 10 plaintiffs and defendants agree to a compromise. This is called settling out of court, meaning before the trial is held. But Barry gets no offer of settlement from Hot Skin. What do you think? Will Barry give up? Will Barry try to hit the president of Hot Skin with a chocolate cream pie? Well, Barry Upset is still very upset, but she relies on her court system and decides to go to trial. The first step, which usually takes a year, involves Barry's lawyer and Hot Skin's lawyers gathering or discovering all the facts in the case. This step is therefore called discovery. The two parties exchange information and ask each other questions. Discovery is like a card game, with each side trying to show their opponent their strongest facts to make their opponent expect a loss and want to settle out of court. Usually this happens, and both parties save the expense and time-consuming court proceedings. At the trial, a judge or the jury, made up of ordinary people, will decide the winner. Almost all of you, like almost all Americans, at some time will be called to serve on a jury. Without citizens doing this duty in our jury system, established by our founding fathers in our Constitution, our system would fail. Having juries of citizens decide the cases is one of the important protections of our freedoms. Barry's doctor testifies before a judge and a jury that in her opinion the lotion caused Barry's rash. In some cases, a judge will hear the evidence without a jury. Hot Skin's scientist testifies that the product was thoroughly tested against rashes, and that a rash like Barry's can be caused by stress and excitement. The trial closes with the judge explaining to the jury what the law allows them to decide and not decide about Barry's case. For example, the judge agrees with Barry's lawyer on the disputed legal point regarding payment for emotional distress and tells the jury that they can require Hot Skin to pay for emotional distress as well as for lost wages. The judge interprets the law, which consists of laws passed by the state legislature and other judges' decisions in similar cases. But the people, in the form of a jury, decide the facts of the major cases, apply the laws to the facts, and determine the winner and the amount of payment. Barry's jury decides in just 3 hours. So what do you think? Did Barry or Hotskin win? Yes, Barry Upset has won and will be given $5,000 to try to make up for the cost of her prom dress and her lost wages, as well as another $5,000 for emotional distress. Hotskin's lawyers appeal for help to the second state court level, or yellow light level, as we have called it. Appeals court is very different from the trial court. For example, it has more than one judge and no jury. The judges at the appeal, or yellow light level, decide only whether the trial judge made any errors in interpreting the law. The panel of judges doesn't hear witnesses. The judges just read the lawyers' written arguments, called briefs, and hear the lawyers' spoken arguments and answers to their questions. Hotskin's lawyers argue that the judge made an error of law when he said that the law allows payment for emotional distress. The appeals court decides that the trial judge's interpretation of the law was wrong and that the law should not cover damages for emotional distress. So the appeals court sends Barry's case back down to the trial court, telling them to subtract that part of the $10,000 that the jury awarded Barry for emotional distress. Neither Barry nor Hotskin try for the third level, or supreme, or red light level of appeal. So it's over. Barry Upset wins $5,000 in her case with Hotskin. We now have seen how courts handle civil, non-criminal cases. Now let's look at a criminal case. This particular case involves a middle-of-the-night break-in and the taking of a television set and VCR. The police find footprints outside a broken window used to enter Mr. Vic Thames' place. They also find a driver's license, which may have been dropped during the break-in. Later, police find and question the owner of the driver's license at his residence. A police officer asks to use the telephone, and on his way, he sees a bedroom full of television sets and VCRs, one like Vic Thames. The owner of the driver's license is arrested and charged with burglary. His name is Steve Suspect. Most crimes, like murder, assault, or burglary, are state crimes handled by the state courts. However, there are some crimes, including large-scale drug dealing, which violate laws enacted by the feds in Washington, D.C., and which apply to the whole country and could be handled by federal courts. Because Mr. Suspect does not have the money to hire a lawyer, the state provides him with a lawyer called a public defender. The lawyer's name is Macomb Free. The state's lawyer, who is opposing Miss Free and trying to prove Mr. Suspect guilty, is called a prosecutor or district attorney. At the initial court hearing, the judge won't let Mr. Suspect go home on a written promise that he will show up for the trial, as is usually the case. Steve Suspect didn't show up at a previous trial, and he has a crime record. Because the judge thinks Mr. Suspect may be dangerous and won't show up at the trial, he asks Mr. Suspect to connect himself or bond himself to the trial with $7,000, which he will lose if he doesn't show up. Mr. Suspect does not have either $7,000 for the bond, nor friends or family, nor a lending company who trust him with the money, so he stays in jail. Mr. Suspect says to his lawyer, "You know, I never forget a face, but in this judge's case, I'll try to make an exception." In serious cases like Mr. Suspect's, our democracy asks a group of typical Americans to make sure that the accused person really should go on trial. This group, or jury, is similar to regular juries of 6 to 12 people. However, this preliminary jury is so large or so grand, usually numbering 23, is called a grand jury. In some areas, the judge acts as the grand jury. Mr. Suspect's grand jury hears the evidence and a majority votes that he probably did it. Their decision is called an indictment. Mr. Suspect tells his lawyer that he doesn't think the jury is so grand, and their indictment causes him no excitement. The vast majority of criminal, like civil defendants, never go to trial because the defendant pleads guilty, trying to get a lighter sentence and believing he or she will be convicted anyway. Or the prosecutor drops the charges because there's not enough evidence to convince a jury. Or the charges are dropped in exchange for a promise that a first offender of a minor crime will commit no more crimes. The public defender, Macomb Free, argues that the stolen goods were found by the police in an illegal search and therefore cannot be used as evidence in court. Our Constitution does not allow our police to forcibly search our homes without prior permission from the court, called a search warrant. The judge rules that because the police were, in effect, invited by Mr. Suspect into his residence, and because the stolen VCR and television were in plain view of the police, the evidence was found legal. The biggest difference between civil cases like Barry's and criminal cases like Steve's involves how the jury decides responsibility. You can lose a civil case if the judge or jury thinks that it is more than likely that you were responsible for the problem. But you can lose a criminal case only if the jury thinks it is beyond a reasonable doubt that you are responsible for the problem. In other words, more than likely guilty is not enough to convict a criminal. In most states, each person in the jury must reach the same conclusion. The courts are sensitive to the fact that losers of criminal trials lose their precious freedom, not just money. The jury convicts Steve Suspect of the burglary. The judge sentences Suspect later after reviewing what is known about him, previous convictions, employment, and addictions, for example, to get an idea whether he is likely to commit more crimes. Mr. Suspect's public defender, Macomb Free, sees little chance for success in appeals court, the second or yellow light level, so she doesn't appeal. Steve Suspect goes to prison. People know that legal disputes can eventually end up in court, so most people usually respect each other's legal rights. Thus, the courts affect all our lives, even if we never go to court ourselves. The more we can rely on our courts instead of violence to peacefully resolve our differences, the higher the quality of the civilization in which we and our children live.
As I said earlier, working together, we at Fortsville Federal Credit Union and you create a positive legacy. Share with others what you know about the United States court system, our rights and freedoms. It is important that as co-owners of this democracy, we understand the basics of our government. Such an understanding is vital to our ability to protect our freedom in the future. I hope you have enjoyed this videotape. We at Fortsville Federal Credit Union are pleased that we could bring it to you.